Two federal court rulings have introduced significant developments in long-running efforts to obtain greater transparency surrounding investigations tied to Jeffrey Epstein. In separate cases, judges authorized the release of sensitive materials, including records linked to grand jury proceedings associated with Ghislaine Maxwell. These decisions mark a notable shift from the traditional secrecy that governs federal grand jury matters. Historically, such materials are tightly protected to preserve the integrity of investigations, safeguard witnesses, and prevent reputational harm to individuals who are never charged. Legal scholars often cite this confidentiality as a cornerstone of the U.S. criminal justice process. The rulings follow recent legislative action mandating broader disclosure of documents connected to Epstein-related investigations. Courts are now weighing how to balance that law's transparency requirements against long-standing judicial norms favoring secrecy. As a result, thousands of pages of investigative material, once expected to remain sealed indefinitely, are being prepared for public release. The implications extend beyond a single case. Legal analysts suggest the decisions could influence how courts interpret disclosure rules in future high-profile investigations, potentially reshaping expectations about public access to criminal probe records. Supporters argue that expanded access promotes accountability, while critics caution that releasing investigative material without context risks misunderstanding or misuse. These legal developments have therefore become both a judicial and public policy issue, raising fundamental questions about transparency, privacy, and precedent within the federal legal system. The recent disclosures stem in part from legislation signed in November 2025 by Donald Trump, designed to increase transparency regarding Epstein-related investigations. The law directs federal agencies to release a wide range of records, commonly referred to as the Epstein files, within specified timelines, subject to legal review and necessary redactions. Supporters of the measure described it as an attempt to address long-standing public demands for clarity about the scope of Epstein's activities and his associations. For years, advocacy groups, journalists, and lawmakers from both major parties had pressed for broader disclosure, arguing that secrecy fueled speculation and undermined trust in institutions. The legislation created new legal pressure on courts to reconsider whether certain materials, including grand jury records, could be unsealed under exceptional circumstances. Judges reviewing the cases have emphasized that their decisions are narrowly tailored to comply with statutory requirements rather than to dismantle grand jury secrecy altogether. Nevertheless, the move represents a departure from how similar materials have historically been handled. Courts are now navigating the tension between statutory transparency mandates and the judiciary's independent authority over criminal procedure. This evolving legal landscape has placed judges, federal prosecutors, and records custodians in the complex position of determining what can be released without violating privacy protections, compromising investigative techniques, or exposing unverified allegations. At the center of the debate is the traditionally confidential nature of grand jury proceedings. Unlike trials, which are adversarial and public, grand juries operate in private to determine whether sufficient evidence exists to bring criminal charges. Confidentiality serves several purposes. It encourages candid testimony, protects witnesses from retaliation, prevents suspects from fleeing or tampering with evidence, and shields individuals who are investigated but never charged. Because of these safeguards, courts have historically been reluctant to disclose such materials, even decades after investigations conclude. Legal experts note that releasing grand jury information is rare and typically occurs only when courts determine there is an overriding public interest or a specific statutory directive requiring disclosure. The current rulings rely on the latter justification, citing Congress's legislative mandate as grounds for reconsidering earlier secrecy assumptions. Critics warn that expanding exceptions could erode confidence in the grand jury system if participants fear their testimony may later become public. Advocates counter that extraordinary cases, particularly those involving widespread public concern, justify measured transparency. The present situation illustrates how legal norms can evolve when legislative action intersects with judicial interpretation, potentially redefining expectations about the permanence of investigative secrecy in historically sensitive cases. Authorities have indicated that the material subject to review and potential disclosure is extensive, reportedly encompassing millions of pages compiled over years of investigations, civil proceedings, and related inquiries. Such a large volume of documentation presents logistical and interpretive challenges. Investigative files often contain raw leads, witness statements, and unverified claims collected during the fact-finding process. By their nature, these records may include information that was never substantiated or introduced in court. Officials from the U.S. Department of Justice have emphasized that inclusion of a person's name in investigative materials does not imply wrongdoing. In complex investigations, individuals may be referenced for reasons ranging from social contact to peripheral witness accounts. To address privacy and legal concerns, agencies are conducting layered reviews to determine what information must remain redacted under federal law, including data related to victims, cooperating witnesses, or ongoing investigative interests. The sheer scale of the material means analysis and contextualization could take years, as journalists, researchers, and legal professionals examine the records. Experts caution that isolated excerpts may not reflect the full evidentiary picture and should be evaluated carefully within their investigative context. Public attention has focused in part on past statements by prominent figures regarding their knowledge of Epstein's conduct. Media organizations have revisited interviews and historical records to compare earlier remarks with newly released documentation. Such scrutiny is common when investigative archives become public. Disclosures often prompt reassessment of timelines, relationships, and the extent of awareness among individuals who moved within similar social or professional circles. Analysts note that apparent inconsistencies in recollection do not necessarily establish legal liability, but can carry political or reputational consequences. Memory, phrasing, and context frequently become subjects of interpretation once historical documents enter the public domain. The renewed examination reflects a broader societal effort to understand how Epstein maintained relationships across influential networks for many years before facing federal prosecution. Observers stress that the presence of associations does not equate to participation in criminal conduct, a distinction repeatedly underscored by investigators. As document reviews continue, clarifying context rather than drawing premature conclusions remains a central challenge for both media outlets and the public. The unfolding disclosures have generated responses across the political spectrum. Lawmakers from both parties have called for careful handling of the materials, emphasizing the need to balance transparency with protections for due process and privacy. Some officials argue that releasing records helps restore public confidence by demonstrating institutional openness. Others caution that selective interpretation of investigative material could deepen polarization if documents are used to advance partisan narratives. In announcing the phased release process, Attorney General Pam Bondi stated that the objective is to comply with the law while ensuring sensitive information is handled responsibly. The department has also outlined procedures for redactions, consistent with federal privacy statutes and victim protection requirements. Bipartisan concern has emerged over how much information should remain shielded, particularly where disclosure could affect individuals not charged with crimes. This debate reflects a long-standing tension in American law between openness in government and safeguarding individual rights. Institutional responses so far suggest a cautious approach aimed at avoiding both excessive secrecy and unrestricted release. Redactions have become a focal point of discussion as documents move toward public availability. Even when transparency laws require disclosure, agencies must still comply with statutes protecting personal data, sealed testimony, and information tied to ongoing legal matters. Legal experts explain that redaction is not unusual in large document releases. Courts often mandate the removal of identifying details for victims or witnesses, as well as information that could expose investigative techniques or infringe constitutional protections. However, incomplete disclosure can lead to skepticism if observers believe key facts remain hidden. Transparency advocates argue that agencies must clearly explain the legal basis for each category of withheld material to maintain credibility. Balancing openness with confidentiality is particularly complex in cases involving both criminal proceedings and civil litigation histories. Judges overseeing the process have indicated they will continue reviewing disputes over what must be released versus what may remain sealed. The outcome of these determinations could influence how future courts interpret disclosure obligations in similarly sensitive investigations. Beyond immediate political and media attention, the rulings may have lasting effects on how federal courts handle historically significant investigations. If upheld through potential appeals, they could establish a framework for releasing grand jury-related materials under specific legislative authorization. Legal historians compare the moment to earlier transparency disputes involving organized crime or major federal inquiries, where courts gradually expanded public access after balancing competing interests. The current cases may therefore serve as precedents guiding how judges evaluate requests for disclosure decades after alleged crimes occurred. Scholars suggest the decisions could encourage Congress to craft more explicit statutes governing when investigative records should transition from sealed archives to public history. At the same time, courts remain wary of creating a standard that might discourage future witnesses from cooperating with grand juries out of concern their testimony could later be revealed. The long-term impact will likely depend on how narrowly or broadly appellate courts interpret the reasoning behind these initial rulings. The release and analysis of Epstein-related materials is expected to unfold gradually rather than as a single comprehensive disclosure. Courts will continue supervising the process, resolving disputes over redactions, and determining whether additional records can be unsealed. Researchers, journalists, and legal professionals will likely spend years reviewing the documentation to understand its historical and legal significance. As with other large archival releases, new interpretations may emerge over time as records are contextualized alongside previously known evidence. Observers caution that public understanding will depend heavily on careful verification, since investigative files contain varying degrees of reliability. Responsible analysis will require distinguishing between substantiated findings and preliminary allegations recorded during investigative stages. Ultimately, the developments highlight enduring questions about accountability, transparency, and the protection of legal processes. The balance struck in these cases may shape not only how this chapter is understood, but also how future high-profile investigations are documented, preserved, and eventually shared with the public.